There was an interesting OUI case this week from the Court of Appeals. The defendant was charged with an OUI in district court, and he pleaded guilty to the OUI. And it seems like the defendant got the standard treatment for anybody who pleads guilty to an OUI. He lost his license for 45 days. He had to do the driver alcohol education program, and he most likely got probation. However, after the plea, not only did all these things happen, but the defendant claims that he lost his CDL, his commercial driver license. And the defense counsel, prior to the plea, didn't let this defendant know that he might lose his CDL license. Now, I have to be honest, I don't know what happens with a commercial driver's license as a result of a plea. And I don't think most attorneys advise their clients on that. They advise only on the maximum sentence and what's going to happen with the person's driver's license, with the RMV. So this defendant wanted a new case. He filed a motion asking to have the plea basically withdrawn and have a new case, in part based on the fact that he lost his CDL and that he was not advised that this might happen prior to the plea. So the lower court denied his motion for a new trial, and the appeals court affirmed that denial, right? And they said the defense counsel had no requirement to advise on the CDL license. So the appeals court writes, except for the obligation to advise about potential immigration consequences, there is no general duty to advise a client of all possible collateral consequences flowing from a plea, right? So keep that in mind. If you're doing a plea, the lawyer needs to tell you about the maximum and minimum sentences that you could get, your license loss, but he doesn't need to get into things such as what might happen with your CDL license or your employment or anything like that. Right? Aside for immigration consequences, he does not need to discuss all potential consequences of a plea. So I've written a blog post on this, and I will put it in the description below.